Hi, Wes. Scott from Kane and Scott. Today we're going to talk about, can my Chapter 13 bankruptcy be denied? And the short answer is yes. Now, look, again, before we start this, the vast majority of Chapter 13s that get filed are filed and confirmed, and the debtor who remains in the plan will get a discharge. Now, there are cases and situations where, and an attorney should, that you choose should know this. There are criteria for being in a Chapter 13 under Section 109 of the Bankruptcy Code. You have to be an individual. Corporations cannot file a Chapter 13 bankruptcy. Only individuals can. And you must have regular income. If you don't have regular income, you cannot do a Chapter 13 bankruptcy. Now, again, talk to a local bankruptcy attorney about this because if you're going to be employed or that sort of thing, I think you're probably going to be okay. And your debts have to be below a certain threshold. So, if your unsecured debts are under 394,725, or if your secured debts are under 1.184 million, then you can file a Chapter 13 bankruptcy. If those debts are higher than that, then there could be some problems with you filing a Chapter 13 bankruptcy. But again, there's some caveats to that. So you're going to want to talk to local bankruptcy attorneys about your specific situation. Assuming you meet that, Section 1325 of the Bankruptcy Code lays out requirements for confirmation of the plan. You must use your best efforts. In other words, you must give the trustee all of your disposable income, whatever's left over after you pay your reasonable and necessary expenses, and you must pay your creditors what they would have received had you filed a Chapter 7. If your creditors in a 7 would have received $10,000, that's what you must pay them in a Chapter 13 bankruptcy. Now, you must pay them $10,000 over the life of the plan, when the time is right. When you are ready, reach out to Kane and Scott. You'll be so thankful you did. Have a good day.